when I'm looking at this next story, I'm outraged that this is a lawsuit, but I'm also outraged at the defendant's conduct. So let's take a look at stealing a vibe, stealing an Instagram account's vibe. Plaintiffs Sydney Nicole Gifford and Sydney Nicole LLC filed this complaint against Alyssa Sheil and Alyssa Sheil LLC. These are competing Instagram accounts, basically. Gifford is an influencer with 500,000 followers, an Amazon storefront, Instagram, TikTok, and an LLC. Sheil is a influencer with similar Amazon storefront, bio.site, Instagram, TikTok, LLC. Over the past 5 years, Sydney has devoted hundreds of hours to establish her unique brand. Sydney has become well known for promoting certain goods, including household goods, apparel, accessories, through original photo and video works. Sydney spends 10 hours a day, 7 days a week, researching unique products and services that fit her brand identity, testing and assessing those products, styling photos and videos, promoting such products and services, and editing posts for plaintiffs' platforms. She's the owner of several copyrights, etc. December 7th, 2022, Sydney first met Sheil, Alyssa Sheil, in person in Texas. The parties met with the intent of supporting one another. The parties then met in January to conduct a photo shoot together for posting on their respective accounts. A few days later, Alyssa blocked Sydney. Sheil blocked Gifford from viewing her content on Instagram and TikTok. Around this time, the content posted on defendants' platforms changed ostensibly. Defendants began to publish posts that replicated the neutral, beige, and cream aesthetic of plaintiffs' brand identity, featured the same or substantially similar Amazon products, and contains styling and textual captions replacing those of plaintiffs' posts. I'm not going to keep you in suspense for any longer. Let's take a look at the exhibit and see what they're claiming is protected. So here is Exhibit A on its side because the actual pictures are on their side. Side-by-side comparison of plaintiffs' posts and infringing material. So you can see for yourself. The left photo, Sydney Nicole's post, has a sweater. Yeah, so in these two photos, they're wearing the same outfit or a similar outfit. But okay, you cannot copyright. You're going to get into this. Before we go any further, having seen that first photo, you need to remember something. You can't copyright everything. You don't own everything. You only own what you create, what you fix in a tangible medium of expression, what you photograph, what you knit, what you 3D print, what you record when you play an instrument or sing. That's what you own. You don't own, for example, white walls, beige colors. These are concepts. People wearing clothing, an outfit. These are not copyrightable things. So when I look at this, I just see two people wearing the same outfit. Now, there are other allegations here. There are other unfair business practice allegations here. So maybe it rises to some kind of claim, not copyright, after you see how much of this there is. This is the first one. Let's go through some more. Here you have them wearing a similar outfit on December 15th. Here they've got similar coffee tables, sort of round cylindrical coffee tables. Here they've got the similar write-on acrylic fridge calendar things. These are all products that are available on Amazon. Here we have two what looks like living rooms done up with similar aesthetics. The coffee tables are in the middle. The couch is an L-shaped couch. The rugs are different. The flooring material is a different choice of flooring material, but the walls are white. Here they're wearing the same pajamas. Again, although I think those are two different colors. Here they have the same chair and desks. Here they have the same pots and pans. Here they're wearing two different dresses. Okay, these are different dresses. It even shows it in the post. One's the Pumier and one's the Rioria or whatever. Here they're wearing two different puffy coats. They're even got different names. You had me until then that it was, maybe if there was more of this. Let's keep going. There's actually more of this. So different poses, similar poses on these photos. Similar outfits here. Similar phone cases. Similar picture of the calendar on the fridge. We've already seen these pictures of the similar desk. No idea what this one's supposed to be. They're wearing completely different outfits and doing completely different things. But here's a similar purse or bag. Here's a similar doormat, the same doormat. Similar, I don't know, tree. I can't say it's a similar tree. They got different trees. They're both wearing rings on their fingers. Some of this is ridiculously not an infringement of copyright. Like a picture of a person's hand wearing rings, you don't own that. You own your picture. You can't own other people's pictures or prevent people from taking pictures of their hands wearing rings. They're not even in the same background. Like, why doesn't... If she's infringing, she should be infringing by copying the après-ski pillow and the other aesthetics. They have the same lamp. Still don't understand what this one is. They have the same desk, but they've got different setups on their desks. This one, they've even got different chairs this time. TikTok content. I think they're trying to show the beige, cream, brown aesthetic. That you do not own any of that in any way whatsoever. We'll call this an opportunity to talk about the merger doctrine. This is a rule of copyright law. Basically, there are some other limits on how much you can copyright things. I'll use this exact example. If I make a cream and brown and white aesthetic for my Instagram channel, can I then go and use the American court system to prevent others, for the life of my copyright, from using a cream, brown, beige aesthetic? First, let's forget for a moment that I'm probably not the first one to use a cream, brown, beige aesthetic. She's probably got competition that came before her that used a similar aesthetic. Second, she doesn't make any of these things. She's just buying products off Amazon. I'm not impressed in the legal sense that this is some kind of ownership of something, of a style. No. When we say trade dress, okay, like Goats on a Hot Tin Roof was given trade dress, so you can have wacky things as trade dress, but this is more of the aesthetic of your store. Instead, I look at this and say, like, no, this is people's homes, and these are products that you've put in your home in the hopes of selling them on Instagram. This is like if two different grocery stores, stock the same items and happen to look similar inside. As in, when you have all the items on the shelves, they both look like they've got a bunch of items on the shelves. That's what this is, in my opinion, so far. They've got similar, but not the same mirror and not the same foyer table. They do have what seems to be the same couch cushions, or I guess those aren't cushions, those are actual seats. They have similar bags, black bags on the left and white bags on the left and black bags on the different black bags. They're different black and white bags. They have similar but also different earrings. They had open boxing videos. Well, guess what? There's only so many ways you can show how you open a box. You can't copyright opening a box. You can't copyright opening a box on a living room floor on a cylindrical wooden coffee table. That's merger doctrine. There's only so many ways to express yourself. Therefore, you can't copyright the basic ways to express yourself. Merger doctrine would apply to things like the musical notes. You know, do, re, mi, fa, sol, la, ti, do. Great. I just sang do, re, mi, fa, sol, la, ti, do. Can I copyright those notes? No, everybody has to use them to make more notes. You can't copyright the notes. So she's copywriting basic elements, scène faire, the basic background elements to make a scene. When you make an Instagram post of at-home lifestyle things, you have to take pictures of the things you ordered from Amazon and how you set them up in your home and how you styled your home. That's not unfair business competition. Here they're complaining that one person bought a Lego Porsche and another person bought a Lego Star Wars. Here's them laying out outfits in totally different ways. Here they have the same bench. I'm only halfway through this. Here they have the same outfits. I don't know about that one. I don't know about those. I don't agree about those. We'll stop there for brevity. Defendants, by and through their Instagram account, have infringed on plaintiff's works by replicating photos, videos, products, captions, and styling of many of plaintiff's posts. Plaintiff posted a video of Sydney visiting an institution called the Tox Shop. Plaintiff's video featured footage of the doormat. Wait, that's not even her doormat. 2 weeks later, defendants posted a photo of the very same institution featuring nearly identical footage. So they shot the same footage. This is unbelievable. So if I went to Mount Rushmore and I shot footage of Mount Rushmore from the viewing spot, the scenic overlook or whatever, then somebody else comes along and shoots the same footage. That's not copyright infringement. You own only your individual copy. You don't own preventing everyone from posting their video of Mount Rushmore because you got there first, and you didn't even get there first. If this was even possible, she didn't even get there first. She's definitely not the first person to go to the store and video the store. So then they go into basically what we just talked about. They replicate the posts at a similar time or shortly thereafter. Defendants have engaged in a pattern of replicating plaintiffs' idea lists. Here's a copy of what looks like Amazon wish lists or idea lists, and they've got substantially similar selections of products. You can have a copyright in the selection and arrangement of something, so there's a way you could try to prove that someone made a selection and arrangement and then someone else copied it instead of making their own selection and arrangement. That is possible. That was the telephone book case. That was Feist. Plaintiffs posted an Amazon storefront photo November 21st. 5 days later, defendants posted the same Amazon storefront photo. This is sounding more like an unfair business practice than a copyright case. I don't know if it's properly pled as a copyright case. I guess it's an interesting theory. If you look at their websites, they have similar aesthetics, but then again, you can't copyright arranging photos, in a grid. You can copyright, I guess, what photos you select to arrange in the grid and how you arrange them. If there's enough of a selection to that, yes. So if their websites are similar enough, that could be copyright infringement. Many of the articles of apparel featured substantial similarities to those of plaintiff's collection. Selection of apparel, I don't know. Let's see what their counts are. The owner of a copyright has exclusive rights. Gifford owns a copyright to each photo, video, text, caption, and in-video text. Defendants have infringed by copying constituent elements of plaintiff's works that are original and by reproducing plaintiff's copyrighted works. So let me explain what that means. That means that the plaintiff is going to have to prove that parts of those photos, that elements of those photos were protected by copyright, are protected by copyright. Not just we chose the same Amazon products, but we chose the same thing that's protected by a copyright. This would be way more obvious if one of them was stealing the other's artwork. If Gifford was drawing pictures and Sheil was stealing the pictures and posting them on her Instagram, that would be copyright infringement. If Gifford is ordering a selection of 5 Amazon products and posting them on her Instagram, and then Sheil is ordering the same 5 Amazon products and posting them on her Instagram, I don't know where the copyright infringement is in there. I can see the claim. I can see that it's some kind of unfair competition at some level. Play hyperbole with me. We never use hyperbole for good things. We always use it for bad in society. But there's actually a really good way to use hyperbole. Use hyperbole to find the boundary conditions of something. So in this case, is there a amount of copying of one's Instagram posts that reaches a level that you're just literally copying them word for word? Yes, okay, that's copyright infringement. You're recreating the exact same photos exactly. Yes, okay, maybe that could be copyright infringement. If you're just selecting the same products, okay, so let's say you've got 2 grocery stores and one of the grocery stores is successful and historic, has hundreds of years of business or whatever. And the other grocery store is some guy who's never run a grocery store. So his technique is to go into your good grocery store and copy down what products you buy and in what quantities and everything, and then go to his grocery store and order the same ratios of products and put them in the same places on the shelves, basically making a little mini version of your grocery store, but it's his, because he doesn't know how to run one, so he's just going to copy it. Yeah, that probably does amount to some kind of unfair business practice. It's really close to the line, though, of so basic that if your business is only succeeding because you're buying the right products and your competition doesn't have to succeed that way because they can just copy what products you buy, yeah, I could see how that makes some kind of a claim. So on one hand, I have some sympathy for Gifford. On the other hand, this is a really borderline light claim in the realm of copyright. They try to make the argument that each act is a separate act of infringement so they can claim for more damages later. And they claim for all the damages they need to claim profits and statutory damages and such. You get to choose. You don't get to get all the things, but you do get to choose whether you want, one set of damages or the other. They also want injunctive relief preventing her from doing this more. That seems more likely, that you would get injunctive relief preventing the defendant from continuing to copy your brand and instead make their own. On the other hand, beige, white, brown is not enough for a brand. That's like every brand is beige, white, brown these days. Every home style brand is beige, white, brown, or maybe black in there sometimes too. Vicarious copyright infringement. This is saying that others have reposted her infringing material. And this actually survived a motion to dismiss. I'll tell you what doesn't survive a motion to dismiss later. But this survived a motion to dismiss, so this is still alive. Digital Millennium copyright violation, as in there was a copyright violated and also the copyright management information, as in author and such, was removed and not reposted correctly, which of course it wouldn't be. And there's a violation for that. Trade dress infringement. The overall color, combination, texture, graphics of the goods and services in question, except she's not selling Instagram accounts. She's not selling photos of products. She's selling the products. So is it trade dress infringement when your Instagram has a look and feel to it so that you can sell products? So you go to a grocery store, or let's make it more relevant. You go to a lifestyle product store, a home store. You go to the home store and it is white and brown and gray and black and beige. And it has a bunch of lifestyle products on the shelves. Is it able to trademark white, beige, brown as the colors of the store? I don't think so. I mean, I don't see how you could trademark that all by itself. Maybe the trade dress, as in we use a certain pattern of those colors, or we've built the building to have a certain look to it. It looks like a luxury lifestyle store, less like just a standard brick and mortar, windows and doors. If we've done more to it, maybe. I don't see how having a bare bones Instagram and website is enough for trade dress infringement. It could be that the websites infringe on each other. Sure, I'm still open to that one. It could be that the defendant's website infringes. Plaintiffs have a distinctive trade dress of monochrome cream gray and beige, coupled with sophisticated styling of Amazon products. So they're trying to claim trade dress because they sell certain products. I do not agree with that. Plaintiffs have gained recognition for their distinctive trade dress, so they're trying to claim secondary meaning if necessary. In fact, I think trade dress might require secondary meaning. I'm not sure. Defendants have intentionally copied the trade dress. Misappropriation. Misappropriation would be copying things about a person. There are some privacy laws. I really don't even know what California, I think it's just California, Texas. I don't even know what the Western District of Texas's law, or what Texas's laws are on misappropriation of one's identity. But it's basically, as far as I'm aware, misappropriation is like identity theft. So someone is trying to copy Gifford's likeness and piggyback off of it. It's kind of like trademark. Tortious interference with prospective business relations. We saw that in the Honey case. that defendants, in this case, defendants' actions in copying are taking business away from plaintiffs. Defendants acted with knowledge that defendants' conduct was substantially certain to cause interference, unfair trade practices, unfair competition. That defendants' conduct took business unfairly. Unjust enrichment means you got something you weren't entitled to. I believe that was thrown out already. Some of the counts overlap with federal copyright law and federal trademark law, and the judge will throw those out, the underlying claims that are preempted by the federal claims. So they're asking for unspecified damages and injunctive relief. So yeah, that's a remarkable one. Here's the misappropriation photos, where they're saying the defendants are trying to make themselves look like the plaintiffs. They even got similar tattoos to the plaintiffs. The websites, I don't know, those websites don't look too terribly creative to me. I've made some creative websites in my time, and those are just buttons and colors. The Amazon storefront, oh my God, the Amazon storefront has products across the top. No, duplicate banner and profile picture. That banner is not a duplicate. That profile picture is not a duplicate. The photos that are posted, some of them are the same, sure, but it's not a duplicate. So I appreciate that something is going on here. I don't appreciate the over-the-top, like, everything that's similar is mine. How is this one the same? Again, you have to remember, these people didn't make the website with the bubble and the banner. This is how their website was made for them by Amazon. This is their profile website on Amazon. So they're not selecting a circle and a banner and it's the same. They're just choosing pictures to put into a predetermined place. And these are different. You cannot copyright girls with wavy or straight hair taking selfies for their profile pictures. You might be able to copyright a selection and arrangement of ideas lists, especially if you can show that one person had access to the other person's idea list and then copied it. That's a bigger deal. That's the closest thing to an actual copyright infringement. Not a big copyright infringement, but closer. Here we've got things circled on this one that don't even exist, so I don't even know what to make of that. Here's the pattern of copying. They both apparently made their bed, but the defendants made their bed 6 days later. They both wore pajamas on the same day. They both had messy bedrooms 2 months later, apparently, on this one. They had a sweater and baggy jeans, but also different baggy jeans, 7 days approximately later. They stored their clothes in drawers in similar ways and did videos about it within the same 2 weeks. They folded clothes or laid out an outfit that was similar within 2 months of each other. They wore a similar bikini with white flowers, black bikini with white flowers, very similar, and we did that within 7 days of each other. They laid out their glasses, which are all different glasses, sunglasses. They laid out their sunglasses in a similar grid pattern, a month and a half after each other. And that's the end of it. And I am super freaking dubious. First off, they're just both doing like the bare minimum. They're doing modeling on Instagram and selling Amazon products. So there's a lot that's not going to be protectable or copyrightable or enforceable or anything like that. There's a lot of it. And the judge, with the help of the attorneys, is going to have to tease this out for the jury, exactly what is considered infringement and what is not considered infringement. Both copyright infringement, but also unfair trade practices and trademark and trade dress and all that. So that's a very complicated case for what I can only imagine is, I guess it's maybe not a small amount of money. I'm assuming that there are large amounts of money involved for these kinds of people doing this kind of selling. But I guess it's enough to have lawyers involved and fight over it. Okay, I'm going to give you an example. I had a client come into my office a long time ago, and I'm gonna make this an anonymous, not confidential example by not using their actual idea. I'm going to modify it. So I'm not telling you a real client's idea. I'm telling you I'm giving you something that'll give you the same feeling. Client came into my office and said, I have this awesome idea. I want to patent this idea. I'm going to sew 2 shirts together. And I was like, what do you mean? Like, well, like what? Somebody wants a wacky shirt with like half their sports team and half a tuxedo or something. Like, we're going to sew 2 shirts together. I want to patent that, sewing 2 shirts together. And I was like, you can't patent that. That's not like a novel idea in the field. Plus, I'm not a patent attorney. Well, how am I going to succeed in business, without a patent then? And I'm like, well, you're going to have to make the very best website and have the best social media presence and have the best prices and have the best quality. And even then, like, you're still going to, anybody who has any money and likes your idea can just walk in and start doing their own sewing two shirts together. So it wasn't the greatest idea to have an unprotectable idea as the basis for your business. Hey, look at what I'm doing. If someone came along and made a YouTube channel about telling people about legal cases and such and did a better job than me or reached more people than me, they would have a bigger channel like Legal Eagle or Steve Lato, etc. That's great. I don't feel like they've infringed on something because they are also talking head legal review videos. That's not something that I can or would or ever try to trademark or copyright. So I don't understand the level of, should I say, arrogance, business self-interest, or whatever, when you think you can copyright putting sunglasses in a grid. I guess if they're trying to show a larger pattern in practice of an overall situation, like, okay, the glasses alone isn't a problem, but look, it's one more thing in a whole pattern of behavior from the defendant. Sure, I get that. They're trying to make the case that she's copying their business. But also what their business is not particularly creative and not particularly protectable, which I guess is where I'm going to leave it. We're still waiting for further rulings in this case. It's just survived a motion to dismiss, which is a big deal, and that means that there will be discovery and there will be potentially a motion for summary judgment or jury trial. I'll keep you up to date on Gifford versus Sheil. Let me know what you think in the comments below.